Hey, I'm Nancy Cavey, National ERISA and IDI Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast isn't legal advice. The Florida Bar Association says I've got to say that, so I've done that. But nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. So off we go. If you are on disability benefits, in other words, you're on claim, or you're in the process of applying for benefits, I think there's a lot that you need to know. But one of the most important things you need to know is one of the first defenses that a disability carrier will raise to your disability claim is what's called a misrepresentation defense. And I'm going to talk to you today about that misrepresentation defense, how to avoid making them, and how to avoid getting a letter from the disability carrier that says, too bad, so sad, we're not paying your benefits because of a misrepresentation on your application or enrollment forms. So we're going to talk about three things today. One, what does rescinding a disability insurance policy mean? Two, making false statements after you've applied for disability insurance benefits can doom your claim. And thirdly, don't mess with a disability carrier and fail to tell them about your work activity. The tale of how one attorney destroyed his case. Let's take a break for a moment before we get started in this week's episode.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at kvlaw.com today.
Welcome back to Winning Isn't Easy. What does rescinding a disability insurance policy mean? Well, for you, it's going to be sad news and disastrous news. When you file a disability insurance claim, the disability carrier is looking for reasons to deny the claim. And one of the primary reasons that they can deny a claim is a coverage defense based on a misrepresentation, which results in them actually rescinding the disability insurance policy. So what is rescinding a disability insurance policy? Now, the insurance company is going to review your enrollment documents or your application for disability insurance if you have an individual disability insurance policy. They're looking for false statements on your initial policy application or enrollment forms that they can use to deny your coverage. So let me give you an example. Let's say the enrollment or application form asks you if you've gotten medical care of any nature in the 5 years before completing the form. If you deny you saw a chiropractor for cervical problems in that 5-year period of time, and then you file a disability insurance claim because of a herniated cervical disc, there's a good chance that a disability insurance carrier will rescind the policy. And that's exactly what happened to one of my clients when we submitted the application. Rescinding a policy is different from denying a claim. When an insurance company rescinds a policy, it treats the policy as if it never existed. The disability insurance company is going to refund any premium that you sent them, and they're going to deny your claim and say, look, this policy never existed. Had you told the truth, we wouldn't have written this policy. We would have issued a waiver for your cervical condition, or we would have charged you a boatload of premium. It's not uncommon, unfortunately, for courts in this type of situation to uphold the denial of the claim on the basis that the disability insurance company properly rescinded your insurance policy or plan because you made false statements on the application. So what should you do when you're completing an insurance disability application or enrollment form? Look, I know that applying for disability insurance involves a lot of paperwork. I've got my own disability insurance policy. Now, these forms can include a policy application or enrollment forms, supplemental applications or supplemental enrollment forms, medical history questionnaires, statements, and even physical examinations. Some people are inclined to just blast through all this paperwork and rely on their current memory. You should take the time you need to review the questions and answer the questions correctly and thoroughly. This is a final exam that you need to take seriously. That means that you might have to obtain a copy of your medical records and your pharmacy records before you review them, before answering the questions, or consult with a significant other who may know your medical history. Now, If you don't understand a question, you should not gloss through it. You should talk to your HR department, or if you're buying an individual disability insurance policy, talk to the agent. Now, I want you to remember that in some instances, and they're limited, an insurance company can be prohibited from successfully rescinding a policy based on information that you provided to the insurance company's agent. So if the agent says, look, you don't need to put that information in this application or enrollment form, when in fact it should be included, you may have an opportunity to defend the policy rescission. But you're going to have some sort of proof that the agent or the HR told you not to put that information on the policy. Nobody's just going to accept your word for it. Each case is factually, medically, and legally different. So don't think you're going to have an easy win with a policy rescission case. It's better not to go there to begin with. So what should you do if your disability insurance policy is rescinded? Well, if this is an ERISA case based on a policy offered to you by your employer, you're going to have to file within an appeal. You're going to have to do that within 180 days of the date of the denial. Now, some of the reasons that your insurance policy or plan can't be rescinded that you might want to consider arguing is that the purportedly false statement was trivial in nature, that the purportedly false statement was immaterial, that you didn't know you suffered from a medical condition, that you didn't understand the significance of the questions or your answers. Now, on the other hand, there are some arguments that you could raise that I'll tell you that a court is not going to be sympathetic to. One of them is going to be, you didn't understand a question such as prior medical treatment, and your medical records document extensive medical treatment and even time off. Secondly, the court's not going to be sympathetic if you've clearly misrepresented your answers, notwithstanding the fact that you claim that you didn't understand the significance of the question. If you're facing a policy rescission in an individual disability policy, you need to discuss this with an experienced disability attorney, because potentially you can take legal action against the insurance company for a breach of contract and bad faith in attempting to rescind your insurance policy. Why do I say you should consult an attorney if it's an IDI claim? Because quite frankly, there's a lot of money at stake, more money in terms of benefits than if you have an ERISA disability insurance policy. I don't want a disability carrier's denial of coverage based on misrepresentation to be an excuse to deny your disability benefits. And you purchase that policy to provide you with peace of mind. So before you walk away from a policy denial based on a rescission, contact me so that we can actually look at the medical facts, the application, what you put, what the carrier is saying, so that you can make an intelligent decision about whether or not you want to fight this. Got it? All right, let's take a break.